Hello and welcome to the Kenneth Verkaman Law Office Legal Podcast. In this edition, we look at undue influence as a defense to strike a will, a power of attorney, or a gift. One of the major cases to deal with undue influence was the Supreme Court of New Jersey case of Haynes versus First National State Bank of New Jersey. Here, the Supreme Court held that the burden of proof establishing undue influence shifts to the proponent when a will benefits a person who stood in a confidential relationship to the decedent and there were suspicious circumstances which need explanation. The suspicious circumstances need only be slight. Moreover, when the evidence is almost entirely in the possession of one party and the evidence points to the proponent as asserting undue influence, a clear and convincing standard may be applied rather than the normal burden of proof of preponderance of the evidence. Furthermore, the Haynes analysis was extended to situations in which there's a transfer of property where the beneficiary of the property and an attorney is on one side and the donor is on the other. That was determined by the case of Oachs versus Stanton by the New Jersey Appellate Division in 1995. The court in Oachs determined, that's spelled O-A-C-H-S, determined that under circumstances such as these, the donor bears the donee bears the burden of proof to establish the validity of the gift, even in situations where the donee did not dominate the decedent's will. The rule was established to protect the donor from making a decision induced by a confidential relationship the donee possesses with the donor. There, the burden is by clear and convincing standard. The Supreme Court of New Jersey in Pascal versus Pascal, spelled P-A-S-C-A-L-E, in 1998, stated that when a donor makes a gift to a donee that he or she is dependent upon, a presumption arises that the donor does not understand the consequences of his or her act. In these situations, the donee must demonstrate that the donor had disinterested and competent counsel. Likewise, undue influence is conclusive when a mentally or physically weakened donor makes a gift without advice or a means of support to a donee upon which he or she is dependent. Let's say a confidential relationship can be found to exist when one is certain that the parties dealt is on unequal terms. So if someone wants a relative to have a will done, sometimes it's suggested they don't go to that person's same attorney, but go to a different attorney. Let's see. Suspicious circumstances are not required to create a presumption of undue influence with regard to inter vivos gifts, and the presumption of undue influence is more easily raised in an inter vivos transfer. Now, generally, an adult is presumed to be competent to make an inter vivos gift. However, when the party alleges undue influence regarding the gift, the contesting party must prove the undue influence or that a presumption of undue influence should arise. Let's see. And finally, I'd say a presumption of undue influence arises when a confidential relationship exists between the donor and the donee, or where the contestant proves the donee dominated the will of the donor. Let's see. The New Jersey Supreme Court in the landmark case of Emory Dodge, the court explained why a presumption of influence arises in a confidential relationship and stated, quote, "In the application of this rule, it is not necessary that the donee occupied such a dominant position towards the donor as to create an inference that the donor was unable to assert his will in opposition to the donee." Undue influence is oftentimes something that must be determined by the Chancery Division judge in the probate part. And for help in trying to bring a claim in New Jersey to fight a will on the grounds of undue influence, a complaint must be filed within literally a short period of time after the person's death. For representation in probate matters, call the law office of Kenneth Verkaman, 732-572-0500, located at 2053 Woodbridge Avenue, Edison, New Jersey 08817. We're on the web at www.njlaws.com. That's NJLAWS.com. And also centraljerseyelderlaw.com. Thank you and good luck.